In Clarke versus Guardian News Media Ltd, Mrs Justice Steyn determined consequential costs issues following her judgment of the 22nd of August 2025, dismissing Mr Clarke's defamation and data protection claims. Applying the general rule under Rule 44.2, subsection 2a, she ordered the claimant to pay the defendant's costs, as the defendant was the resoundingly successful party. The court then addressed several reserved costs orders concerning an interim non-disclosure application and an amendment and joinder application. Citing Practice Direction 44, the judge made no further order, meaning these reserved costs fell to be treated as costs in the case, payable by the claimant. On the basis of assessment, the court departed from the standard basis, ordering indemnity costs pursuant to Rule 44.3. This was justified by the claimant's unreasonable conduct, including advancing a dishonest case and making baseless allegations of conspiracy and dishonesty against witnesses, consistent with the principle in Esure Services Limited versus Quarcoo. Finally, applying Rule 44.2 subsection 8 and following Bank St Petersburg PJSC versus Arkhangelsky, the court ordered a £3 million payment on account of costs, finding it a reasonable sum and rejecting the claimant's inability to pay as a good reason to refuse. The application to extend time for an appeal and for a stay of the costs order was refused.
Quote, "The claimant's pleaded case and his evidence at trial on the defence of truth contained many statements that I have found were untrue and dishonest. In Esure Services Limited versus Quarcoo, if a court has found that a claim has been brought or maintained dishonestly, it will be normal for a court to seek to mark its disapproval by making an order for indemnity costs. That is, sadly, the position here."
For a detailed summary of this decision, visit tmclegal.co.uk.